Today we're with David Shapiro. David is a criminal defense attorney in San Diego, California. He's agreed to answer some online questions related to weapons violations. If you're in a situation where you're looking for a criminal attorney, which you probably are by watching this video, a few things to consider. One, you want to find an attorney that has a lot of trial experience. Surprisingly, some criminal defense attorneys do not have a lot of trial experience. David does. And the other thing you can do to kind of take some control and put some control in your own hands is take a look at their own online reviews. Previous clients have taken a look or had the experience of working with them and see what they have to say. In the case of David, he's got some excellent online reviews. Google, Yelp, Avo. In Avo, he actually has a 10 of 10 perfect score. And at the time of this, he has over 50 client reviews on there. So something you can take a look at. With that said, you can also post some questions here. One note is you probably don't want to post anything personal. So if it is a question that you have that can be generalized, post it. He'll get back to you within about 24 to 48 hours. And if it's something more specific, just reach out to him directly. With that said, David, let's go into our first question that was posted. I have an out-of-state felony. Is there any way I can legally own a gun?
Well, that's a good question. Legally speaking, federally, you might not be able to own a gun no matter what if it qualifies federally, and that's the problem sometimes. Sometimes you get convicted of a case, even in California, and you might only have a ban on firearms for 10 years if it's a domestic violence offense, but the issue is federally, can you ever possess a gun? Out of state, usually the rule is if you're transferring or applying an out of state prior to California, is would that offense be a felony? Would that offense qualify as an offense here in California? So that's the first step usually. You know, what would this conviction basically translate to from an out-of-state, say you're in Washington, what would that Washington conviction translate to the equivalent of here in California, if anything? But I think federally you still have a problem. So before you go out, and I guess if you try legally to get a gun, you'll find out if you can or not legally. But if you don't go that route, you want to make sure you know what your rights are and what is legal and what is not illegal, because you have problems a lot of times if you're a felon in possession of a firearm, what would be a normal misdemeanor conduct, misdemeanor charge for someone without a past could be elevated to a felony just for simple possession, even if the weapon at one point was lawfully registered in your name.
Okay. The next question that was posted, this is actually specific to you, less of a law question, but how much will you charge to discuss my case with you?
Well, generally speaking, we have a free consultation set up either with myself or one of my assistants here at the office. That usually, give or take, is around 30 minutes or change. Sufficient time to gather enough information about the case. If it's something where you want to bring me on as a consultant or want me to review documents in excess of that general half an hour to hour time frame, I would generally quote an hourly fee. A couple $100 an hour, depending on the complexity of it, depending on, all honesty, how busy I am. Obviously, the busier I am, the more in demand the time might be, the more my obligations need to be to my current clients, whether it's court appearances or preparation for them. So, we're pretty flexible here. A lot of attorneys, this office included, my office included, obviously, does offer free consultations. But after a while, a lot of times people come in and they want, to talk to you for 3-4 hours. And they'll realize real quick when they hire my office, specifically working with an attorney like myself, they'll realize how much individual attention my current clients get and how at times it is difficult to really sit down with a prospective client for hours upon hours, certainly for free. So, we're pretty flexible. That's a good thing about being in the law office of David Shapiro is I get to sort of dictate how much I would charge. No more than a couple of $100 an hour, give or take if it exceeds the free consultation that my office promises.
Okay, excellent. Next question, and this is the final question. I've been charged with the DUI, and I had a loaded pistol in my car. It was my friend's gun. What types of defenses do I have available to me?
Well, first and foremost is you want to look at it no matter what was found in the car. A gun, whether it's yours, your friend's, whatever, is the reason for the initial encounter with law enforcement to begin with. And that's no different in any case than a regular DUI, meaning why were you pulled over, why were you detained? How did they then get into the area in the vehicle, they meaning law enforcement, where the gun was found? So you might have a search and seizure issue as it relates to suppressing evidence that was found after an improper stop. The argument being, well, you should never have been stopped, therefore the DUI, the blood alcohol level, and certainly what was found in the vehicle after the improper stop should be suppressed or kept out of evidence. So that's one. That is a legal constitutional search and seizure issue. That is not necessarily an affirmative defense to the charge, meaning that if you litigate that aspect of your case, that motion to suppress, let's say, is denied, or if law enforcement did have a legal basis to pull you over and search the vehicle to the extent that they found the gun, then the focus would be on, well, what defenses would you have if the case were to proceed to trial? Well, we've done many blogs and discussed at length certain defenses to DUIs, but as it relates to the weapons charge, it would need to be, first and foremost, that it was where it was within the vehicle, what's constructive possession, what's actual possession, what statements, if any, did you make even saying that you knew that it was in there. There is an intent element to a certain degree as it relates to weapons charges. And there's certain things that could be flushed out as the case develops against you. If your friend was in the car, then the issue is your friend going to be willing to step up and take responsibility for his or her gun that was in your car? Where the gun was found in the vehicle is important too. If it's found in the center console right next to you, it's going to be hard for you to say you didn't know about it. If it's found, behind the passenger seat or in your friend's duffel bag that that he left in your car, he or she left in your car, that's a whole other issue. So, depending on the specific statute, depending on the specific charge, the specific facts of your case, you want to make sure you hire an attorney that, one, knows what they're doing, and two, has the resources and the abilities to issue spot and to say, okay, well, there may be an issue here. Or there's not an issue at trial, but there might be an issue with suppressing the evidence. So it's important. There's a lot of things that get flushed out. To really narrow it down, I would need to see the discovery, the specific reports, and what law enforcement will be alleging. But generally speaking, those are your different avenues of defenses moving forward.
Okay. Well, for those of you who post your questions, hopefully those help. Obviously, you can reach out to David directly. For anyone else watching, same goes. You can post your comments below. And with that said, David, I want to thank you for your time.
Thank you very much. My pleasure.